Shall we start, please? If you can have your seat. Thank you. Okay, so welcome back to the last session of our exciting conference. I know that we all are a bit tired, but I really trust that, we can really enjoy this last session of our conference that, as you know, will be devoted to an analysis and assessment of the 3 additional instruments which supplement the United Nations Conventions Against Transnational Organized Crime. So since the time is very short and we have several presentations and discussion, I will really limit my role to introduce the first speaker of this panel. And I'm very pleased to introduce Fabrizio Sarrica, who is a UNODC research expert on trafficking persons. He has been working since the beginning of the 2000s, the United Nations office in Vienna. And actually, as a sociologist and a researcher myself, very much interested in the topic of trafficking and smuggling in human beings, I would like to remind that Fabrizio is also the main author of 2 of the main reports actually launched by UNODC devoted to the phenomenon of trafficking in persons. So Fabrizio Sarrica will make a presentation expressly focusing on the protocol against trafficking persons. So, please.
Thank you, Monica. And thank you, Serena. And I would like to express also myself my gratitude to the University of Ferrara, to the Macro, and to the organizers for inviting me here and to talk about the Trafficking Persons Protocol. And I actually would like to keep the fil rouge of the previous panel, and also to discuss a bit, to continue this idea of discussing the gap between the books and what is on the papers, what's the rights of the victims, and the provisions of on this case of the protocol, and the reality. So I will talk about some of the results emerging from the Global Report on Trafficking in Persons. The Global Report, that's my job. I work on the production. The team that I'm leading is producing a global report. It has been mandated by the General Assembly in 2010, and the General Assembly resolution is mandating UNODC to collect and report data on trafficking in persons at national, national, regional, international level on trafficking in persons, which is quite an interesting mandate, because the General Assembly is the member states are telling us you can investigate also what we are doing at national level. So we have been collecting data. Now we have a database with information since the year 2003, which is also the year of the entry into force of the protocol. The global report is mainly about trafficking patterns and flows. So we study the characteristics, the victims, vulnerabilities, and the flows. So the main countries of origin, the main countries of destination, and so forth. But today I will present also another part of the report, which is mainly on the monitoring how the Trafficking in Persons Protocol is implemented, and I will also present some historical results. Of course, as said before by Professor Nando Dalla Chiesa and by our friends Ruth from Victim Support Europe, we can have the best provisions of the world in the convention or in the protocol, but then if victims are not really assisted, then we fail. And if victims are actually not detected, because national authorities are not seeing this crime happening in the territories where on their competence, we fail to protect and to convict the traffickers for that matter. So I will pass immediately to the status of legislation. We monitor constantly through our networks of field offices the status of the legislation on trafficking in persons at local level. So on this chart, you will see the evolution of the national legislation over the last 15 years. Since December 2003, the moment of the entry into force of the Palermo Protocol, and August 2018, which is the date of reference of the last edition of the Global Report, which was published in 2018. So the blue lines, the blue columns, represent the countries around the world that have a legislation, a specific offense on trafficking in persons, in line with the Palermo Protocol definition. So as you can see, in December 2003, only 33 member states, 18% of the member states of the United Nations, had a legislation defining a specific offense on trafficking in persons, defining trafficking as defined in the protocol. Though the green columns, 59%, almost 60%, were those countries that did not criminalize at all trafficking in persons. So trafficking in persons was not a crime. Of course, member state or local authorities were probably detecting, recording, prosecuting these crimes under other provisions, but of course those provisions were not, did not consider the victims as victims of trafficking. Those provisions could not and cannot be used for international cooperation according to the UNTOC and so forth. So after 5 years, so 5 years later, the entry into force of the protocol, the number of countries with the proper legislation on trafficking in persons triplicated. So we could see a very strong push of the protocol, at least when we talk about the specific offense, so having the legislation in line with the Palermo Protocol. And over the years, you see a gradual evolution towards not only universal ratification of the protocol, but also universal introduction of the concept of trafficking persons as we have it in the Palermo Protocol. So nowadays, the vast majority of the countries do have a legislation that is criminalizing trafficking persons in all its aspects, on most of its aspects, and some few countries, even if these countries are very, let's say, in terms of demography, are very important, that do not criminalize trafficking persons or criminalize only some aspects of trafficking persons. For instance, they only criminalize trafficking for child trafficking. This is the case still in some West African countries, or trafficking in women. This is the case in some East Asian countries, or trafficking of foreigners. And this is the case in some countries in South America. For some reason, there is this historical legacy, and this region of the world used to be, and some of these countries are still characterized to criminalize only these aspects of trafficking. So this is the status of the legislations around the world. But how are these legislation used? So for trafficking in persons, for the global report, we record the number of victims detected by national authorities around the world and the number of people investigated, prosecuted, and convicted for trafficking in persons. Just as a reference, I would like to mention that in the global report that we published in 2009, we measured that for the year 2007, only, for the year 2007, 40% of the member states around the world did not record a single conviction for trafficking in persons. So in 40% of the world, so to say, there was total impunity. And these included countries with no legislation or countries with legislation. And 17% recorded some conviction, but less than 10 per year. So virtual impunity. Now the situation has improved. with this chart, which is very complex, but I will make it very simple. If you, this shows the evolution concerning the number of victims detected, the number of victims of trafficking persons detected globally. And if you see the dark line and the numbers on this dark line over the period that we consider, this represents the number, the average number of victims detected in each country. So in the year 2010, on average, each member state was, at least those that we cover in our report, each member state was detecting 150 victims. So of course, some countries were detecting more, and some countries were detected less, some countries 0. But on average, around the world, every country was detecting 150 victims. Now in 2016, the year of reference of the previous report, this number is 254, so there is an increase of 60%. Beside the numbers, it's clear that there is an increasing number of victims that are detected. And we know that the detection is very important because then detected victim can be assisted, even if this is not the case as emerged from the presentation. Not always this the case as emerged from the presentation of Victim Support Europe. But at least we see some improvement. And the same for the people, the traffickers convicted. So we see that over the years, starting from a very, let's say, widespread impunity, as said before, now we reach some increasing numbers in terms of people convicted for trafficking persons. Also here we see that some regions of the world are detecting more, some regions of the world are detecting less. For instance, in Africa and the Middle East, we see a very important increase in number of convictions, but sometimes this increase is really passing from 0 to 5. So even if it is impressive in terms of statistics, but in absolute numbers is still extremely low. Of course, the situation is changing and is different if we look at the different regions of the world. There are regions of the world that are detecting many victims and convicting many traffickers, or at least more traffickers than other regions, and some parts where we have still impunity. This increasing number of victims detection and increasing number of convictions is clearly connected to an action by the national authorities, by the governments. So we have assessed a large number of countries, about 80 countries, all those countries where we notice some increase. And this increase in number of victims detected or in number of convictions was always somehow connected to some action. For instance, here I brought some examples. In Nepal, the introduction of the new legislation in 2007, 2008, then was followed by an increasing number of victims detected. Then the National Action Plan that was introduced in the year 2012, then also that was followed by the increasing number of victims detected or increasing number of convictions. And so forth for all countries around the world. So when there is a concrete action by the national authorities, that could be a national action plan with a specific budget, for instance, and specific target, then yes, we see some results. As I was saying before, of course, the global pictures still remain with regions that are detecting, on the forefront to combat trafficking in persons, and regions that are, let's say, lacking behind. And this chart is synthesizing this concept. To make a long story short, in this chart, we represent on the corner on the top right, you see those regions, those countries that are detecting more victims and convicting more traffickers. And these are the European countries, Western Europe, Eastern Europe. And then on the bottom left are those countries that are detecting less victims and convicting less traffickers. to the point of 0, for instance, in many countries. So, and this is mainly the case for sub-Saharan African countries, where you can see is extremely low compared to the other regions of the world, but also MENA, countries in the MENA region and Asian countries. So we see that there is, let's say, the response is quite scattered, and different countries and different parts of the world, and of course is connected, clearly connected also to capacity and development. But one thing is important. Those regions of the world where we see a very weak response to trafficking persons are also those countries that are somehow suffering more of trafficking persons. So with this chart, we show that the victims, the origin of victims of trafficking at global level. Most of the victims of trafficking globally are coming from those regions that are experiencing impunity for traffickers and not detecting victims. So sub-Saharan African victims have been detected everywhere around the world, not only in Europe, where it's quite, it's still increasing, especially from West Africa, but also in the MENA regions, of course, also in East Asia and in some part of the Americas. Also the case for East Asian victims. And with this, I pass the word to Monica. Thank you.
Thank you very much, Fabrizio, for this very instructive and, comprehensive view on the latest trends in the field of trafficking in persons. Actually, your conclusions, are pretty worrying, I must say, since, as you said, the countries with the weakest response against trafficking are actually those who are suffering more the phenomenon. So now, it's time to give the floor to the second speaker of our panel, who is Alessandro Spena, who is a professor of criminal law at the University of Palermo. And Alessandro has been dealing with topics related to criminal law, criminalization, and particularly irregular migration. And in fact, his presentation will address the protocol against migrant smuggling. So please, Alessandro, you have the floor.
Can I have a microphone? Okay. Thank you. Thank you to Serena for inviting me. Well, yes, I will deal with the smuggling protocol. I will say something on the logic underlying this protocol, and if I have time, I will also say something on the implementation of the protocol. First of all, I would begin with distinguishing two possible approaches, which are basically two different answers, different possible answers to the question why should states be willing to counter, to fight against migrant smuggling. We can distinguish two different approaches. One can be said to be a state-centered approach, which tackles migrant smuggling basically as a way of fighting against irregular immigration. I would not dwell on the characteristics of this approach because I have no time to do it. A second approach can be dubbed as being migrant sympathetic, in a way that it is aimed at protecting the rights of smuggled migrants, seen as vulnerable subjects. And as vulnerable subjects, they can be, for instance, the object of some kind of exploitation by smugglers, or their rights can be put at risk, such as, for instance, their right to life, or the right to be treated humanly, and the right to human dignity. So, which of these two possible general approaches underlies the UN protocol on smuggling? In my view, the protocol underlies a hybrid approach. which can be inferred, for instance, from the statement of purpose in Article 2, according to which the protocol's aim is to prevent and combat the smuggling of migrants while protecting the rights of smuggled migrants. This statement means, in my view, that the UN protocol on one hand acknowledges that migrants have rights which can be put at risk by smuggling, but on the other hand, the fact that these rights are referred to by using a subordinating conjunction, while, means that the protection of these rights is a subordinated aim, in a sense that it is conceptually different from, though being linked to, the fight against smuggling. So the fight against smuggling is primarily referred to the interest of states to fight against irregular immigration, though it might also violate migrants' rights. Nonetheless, as this point was clearly touched upon by Serena, for instance, this morning, nonetheless, smuggled migrants are surely acknowledged a central role within the protocol. It is not clear what exactly this role is. Are they victims or not? This is a point I will do a little bit later on. But what is sure is that they are acknowledged a central role, and the protocol acknowledges that the figure of the smuggled migrants is some kind of kaleidoscopic figure, having many different facets. First of all, they are acknowledged what we can name a passive or objectual role. They are depicted throughout the protocol as being the object of conduct. And for instance, the very definition of smuggling of migrants is confirming this aspect. The definition is as follows. Now, smuggling is the procurement, in order to obtain some material benefits, of the illegal entry of a person into another state. The conduct of smugglers is construed in causal terms, which means that the position of migrants is put on the side of the result of conduct. It's not a position depicted as some kind of complicity in the conduct of the smugglers. Which means that within the protocol, there is no space, no room for something like a self-smuggling criminalization, which is established expressly by Article 5, which states that migrants should not become liable to criminal prosecution for the fact of having been smuggled. They could be criminalized for other crimes, but not for being accomplices in their own smuggling. But, and this was clearly said by Serena this morning, they are not only acknowledged a merely passive position of merely being the object of conduct, but they are also acknowledged to be claimants, if so to speak. They are acknowledged as being subjects of rights. This can be inferred from many different provisions within the protocol, from very general provisions such as the preamble, the statement of purpose, and the scope of application, but from many other provisions which I have listed in my presentation, but of course I'm not going to do it on them. There are many provisions. What I would like to say here about that is that we can, at least this is what I will argue, we can group these rights into two different categories. On one hand, we quite obviously have the acknowledgement that smuggled migrants have rights against their smugglers. And these rights can be usually are involved in the perpetration of a smuggling relationship. For instance, the right to life, the right not to be tortured, and so on and so forth. But within the protocol, smuggled migrants are also acknowledged to be the bearer of some rights against the states fighting against smuggling, which means that the protocol sets some limits beyond which states cannot go in fighting against smuggling, and these limits are represented by some rights of the smuggled migrants. In my view, from these two different categories of rights, we can derive two kinds of victimizations. We can derive the idea that smuggled migrants are at least possible victims of a history, of a story, if you want, of smuggling. A first dimension of possible victimization, which I call primary victimization, derives from the violation of the rights that smuggled migrants have against their smugglers. And these rights basically have to do with the execution of the smuggling relationship, which entailed the violation of the rights to life, to physical integrity, to human treatment, and so on and so forth. From this perspective, the migrant sympathetic approach in the UN protocol is some kind of external support to the state-centered approach, which means that it provides us with other reasons beyond the reasons that states have to protect their territorial sovereignty to fight against smuggling. But from the other category of rights, we can also infer that smuggled migrants are also recognized a second possible role of victims, which I call secondary victimization of smuggled migrants, which can derive from the violation of the rights that smuggled migrants have vis-à-vis the states, which are willing to fight smuggling. Under this perspective, the migrant sympathetic approach in the UN protocol works as a counterpoint to the state-centered approach. It limits the state-centered approach. And lastly, we maybe can identify a third, more problematic, but a third dimension of possible victimization of smuggled migrants, which we can infer maybe from the fact that the protocol does not merely criminalize as smuggling the mere fact of procuring the foreigner's irregular entrance in a foreign state, but it only criminalizes this conduct insofar as it is performed in order to obtain some material benefit. So what is the meaning of this element? The aim of profit has, in fact, nothing to do with a state-centered approach. If we look at the travaux préparatoires, basically the meaning of this element is that of excluding from responsibility those who act out of humanitarian reasons. But if we assume that in certain cases smuggled migrants can find themselves in a position of vulnerability, which can have the characteristics that this position has, for instance, in the UN protocol on the trafficking in persons, we can also derive a third dimension of possible victimization of smuggled migrants, consisting in their being exploited by the smugglers for profit. Okay, just a few lines on, in 5 minutes on the implementation of the protocol. As of today, 147 states have ratified the protocol, which is not so little, of course, but one problem is that, at least as far as I'm concerned, the impression is that states have been willing to ratify this protocol basically from a state-centered point of view. it seems to me that states are basically interested in fighting against the smuggling of migrants as a way of getting tough on irregular immigration. So we can say that the migrant sympathetic soul part of the UN protocol has been largely disregarded. This can be seen, for instance, at the EU level. EU has ratified the protocol in 2006, but as of today, the basic regulation, EU regulation on smuggling is still the facilitation package in 2002, and this package is driven by a state-centered approach. For instance, the definition of smuggling in Article 1.1, letter A, as the deed of any person who intentionally assists a person who is not national to enter or to transit across the territory of a member state. This definition has these characteristics. First of all, it defines the conduct of smugglers not as the procurement, so not in causal terms, but in terms of complicity. It defines it as a way of assisting smuggled migrants in entering foreign states irregularly. And the very definition of the crime is facilitation, which is a term which hints at a kind of complicity in another man crime. And it is not required that smugglers act out of profit. And moreover, the Article 1.2 of the directive does not require that states excuse subjects who act out of humanitarian reasons. So, to conclude, in my view, the main challenges regarding the implementation of the UN protocol basically are the need to describe the conduct in causal terms and not as kind of complicity, the need to add a name of profit element in the definition, and the need to add also a compelling, compulsory humanitarian defense. Thank you very much for your attention.
Thank you very much, Alessandro, for your very interesting analysis in critical terms also of the contents of this protocol, actually. And again, we come back to what is written in the documents and what actually happens, in reality, because if we think that among those countries who have actually ratified both the trafficking protocol and the smuggling protocol, actually there are some countries who are posed at the core center of some smuggling and trafficking, let's say, important roads, such as Libya and others. So, unfortunately, having ratified instruments like those is not enough, absolutely, because on the other side, it can be reverse, actually, instead of providing support to the victims, being instrument to, engage against smuggling of migrants in a way which is not absolutely coherent with a human rights approach. So thank you very much, Alessandro. So now I'm very, very pleased to give the floor to our last speaker, actually, Miss Simonetta Grassi, who is actually Senior Crime Prevention and Criminal Justice Officer at the UNODC in Vienna, where actually she coordinates the UNODC Global Firearms Program. And I'm particularly pleased to give the floor to Simonetta, since 21 years ago, actually, in my former life, we worked together at the UN as associate experts at that time. So, and together with other colleagues, we developed the global program against transnational organized crime. It was just a few months before the first session of the ad hoc committee on the elaboration of the Convention against transnational organized crime. So we are talking of Jurassic times. It was end of 1998, but I'm very, very pleased. So, Simonetta Grassi will address the firearms protocol in her presentation. So please. Okay.
Thank you very much. Grazie. I'm very, very pleased to speak to you, and I hope I'm the last but not the least of the speakers. My presentation will be a little bit different because I deal with an issue that has traditionally been a little bit neglected in the framework of the Palermo Convention, but is also very relevant in a broader context of arms control. So I will try to explain a little bit, before I speak about the firearms protocol, I will try to give this broader context and then give a very small refresher on what the main essence of the content of the protocol is, and speak then about challenges that as we encounter them through the program that I have the pleasure to coordinate. Let me just see if I'm able to use this technology. All right. So I would first like to start by saying that firearms, especially illicit firearms, they are actually present in most forms of crime. It is so present, so cross-cuttingly present everywhere we see it, in movies everywhere, that we tend to forget about them. So firearms are closely linked. Firearms trafficking is not only a very serious and transnational crime per se by its own merit, but it is very closely linked to other crimes that are actually aggravated by the availability, by the access of firearms by terrorists and criminal groups. And this is the starting point to look at this issue from a cross-cutting perspective. In a way, I would even dare saying that firearms trafficking is one of the most hidden crimes, because we often detect illicit firearms only when they have already reached the wrong hands, when they are being used in crime, in terrorist attacks, and when, in the few cases when then these arms are actually identified and traced, we discover that they had actually been trafficked before. So it is this cross-cutting nature that makes the issue so relevant, but at the same time takes also a little bit away the strength of the topic, if I can say so, because the problem is often absorbed by the other context. So, for example, we have a terrorist attack, the attention goes to the primary offense, and we just take for granted, we know, yeah, firearms were used. But this is important to take into account, because when we speak about the implementation challenges, this is when we will find out why we have these challenges actually. Because this issue is of such a great importance, not only in the context of crime, there are a number of instruments that have been adopted over time that address the broader aspect of arms control, because firearms, unlike other illicit commodities, firearms are not per se illicit. The vast majority of arms are legally produced. You all know that there is a very big, flourishing arms market, legal arms market, and there is in parallel to it also a very big and flourishing illicit market. And these two markets interact with each other. And because this has such a strong impact over time, there has been a push from different angles to address the problem. So if we can simplify a little bit, we have multiple instruments that try to address the problem from complementary angles. There is, as we are discussing in this context, the organized crime or the crime control angle that looks at arms, at illicit trafficking as a form of organized crime. But then there is the disarmament control, or the disarmament or the arms control angle that is mainly tackled in the context in New York or in Geneva, so in other governing bodies and with other contexts and scopes, where we have an instrument that was adopted a few months, 3 months after the Firearms Protocol, and this is the UN Program of Action on Small Arms and Light Weapons. And this is not a legally binding instrument. It is often called a politically binding. For me, this is a term that doesn't really exist. It is a non-binding instrument. It is soft law. And there is also another instrument that was adopted in 2005, which is also very important but not binding, which is the tracing instrument, the international tracing instrument. And then in 2014, the Arms Trade Treaty was adopted. The Arms Trade Treaty is the other legally binding instrument. So we have a set of instruments that address one big common problem from complementary angles. And it is important to take this into account, first of all, because these instruments have never been considered as belonging one to each other. They were all developed in different times, in different contexts, and yet their content is very complementary, and there are also a lot of overlaps. For me, this is not a weakness, this is a strength, because it allows member states to look at this problem from complementary perspectives. But at the same time, the fact that there was this parallel process in New York with the program of action has, in my view, also a bit contributed to delay the adoption of the firearms protocol. Or maybe the protocol was adopted, we don't know yet why, but the fact is that the firearms protocol was not adopted in the year 2000 together with the convention, as you all know. It was adopted 1 year later, because there were more negotiations required on some technical aspects that I will mention in a moment. But the fact is that, just as I said, 3 months later, the same General Assembly adopted the program of action. And if you compare the provisions, the preventive measures in particular, they're very similar. Just that some are more, in the protocol they are binding, and in the program of action they are not binding. So this has also impacted on the success or on the visibility of the firearms protocol. In addition, with the adoption of the Sustainable Development Goals and the agenda for the 2030 agenda, there has been a growing recognition of the fact that, in fact, illicit arms flows, as much as illicit financial flows, impact negatively on development. So one of the target goals, 16.4, commits states to significantly reduce not only illicit financial, but also illicit arms flows. And if you read the sentence, it also continues with strengthen the recovery and return of stolen assets and combat all forms of organized crime. For us, what does it mean? It means that this is an implicit recognition that there are three main elements that really affect global security, if we can say so, and development. And this is illicit financial flows, illicit money, because this is what is most commonly used, illicit arms flows, because this is what gives the tools, but also the financial means and the material means to criminal groups, and then the connected forms of organized crime, of course. So this is implicit a recognition that the centrality of arms trafficking cannot be neglected. Most recently, the Security Council resolution has also acknowledged that there is a growing link between arms trafficking and the availability of these arms in the hands of terrorists. So the resolution 2370 aims at preventing terrorists from acquiring weapons. The content of the resolution is not very innovative. It replicates some of the most relevant provisions that are contained in the instruments already. But the fact of having put terrorism and arms trafficking in connection is already an important acknowledgement. So in this context, if we now look at the firearms protocol, I wanted to stress this before, because we have to see the protocol in this dual connection. The protocol supplements the Organized Crime Convention, but it is also not a standalone instrument in the context of arms control. The approach that is adopted in the firearms protocol, but also in other arms control instruments, is to combine preventive measures with control measures, meaning that in order to be able to prevent and combat arms trafficking, countries need to have a regulatory framework in place that allows them to actually control the arms at every moment at their life cycle. And this is already a challenge by itself. I will get back to it. So on the preventive side, I mentioned all the other instruments. The requirements are multiple and of very technical nature. Countries need to keep records. Countries need to ensure the marking of firearms. Why? Because by having all these measures in place, it will be possible to trace these arms. So if the arms are then used in a criminal context, investigations can be carried out. Without this, it is not possible to identify the origin of the arms. So the protocol's approach is regulate the legal activities surrounding firearms, from manufacturing to transfer. It does not address possession and ownership, and this is also a very important point, because the distinct approaches taken by countries with regard to ownership, who can have weapons, what type of weapons, how many arms, what type of ammunition, can trigger illicit demand for arms. If you just take the example of Canada and United States, Mexico, you have very, very different legal frameworks and different opposite approaches, and this makes it very hard for criminal justice systems to prevent and to counter these forms of crime. In Mexico, for example, the legal regime, what is on paper, is actually very strict. Very few categories of people are allowed to have firearms, and yet they can purchase them with lots of easiness in the neighboring country and then traffic them. So you see here the conflict between what is in the law and what is the reality, and how this impacts then on the security. What is important about the protocol as opposed to the other instruments is that it obliges state parties to introduce also criminal offenses. The criminalization offenses contained in the protocol are mentioned in other instruments, but only in the protocol you find also the definitions of these offenses. So this allows us now with the review mechanism, for example, to be more specific, to look more in concrete terms to which extent countries are really complying with the protocol and implementing provisions that criminalize exactly what is defined as illicit manufacturing, what is defined as illicit trafficking, etc. And this will become extremely important if you look at this phenomenon from the perspective of emerging new technologies. We speak of internet trafficking, we speak of 3D printed weapons. The legal framework, the criminalization offenses on illicit manufacturing, for example, should be able to cover these phenomena. Or the trafficking through postal services is a form of illicit trafficking. So it will be very interesting to see with the review mechanism to which extent countries are really implementing all elements of the definitions of illicit trafficking, illicit manufacturing, and tampering with markings. As far as the preventive measures are concerned, I mentioned before, there are many overlaps, so I will not go into the detail. I just want to mention that because there are so many instruments that address these forms, these preventive measures, they become almost universal. Now, what are the challenges that we have encountered in, because you see, the framework is not the problem in theory, but the implementation is the problem. What is the challenge that we encounter? First of all, as I said at the beginning, this is a multidimensional crime. Often, firearms trafficking does not appear as such. It appears only in the context of other criminal phenomena. There are legal loopholes that exist at the level of not only of criminalization, but also, as I said before, on the level of possession, ownership, transfer controls, which make it more difficult for countries to cooperate among them because just the frameworks alone are sometimes conflicting. And then what, in my view, is the strongest problem is the criminal justice response per se. The lack of I cannot pronounce this name, prioritization. Exactly. And I will come in a second to explain what I mean by that. First of all, I said it is a complex crime. Why? Because there is a legal market. Almost all most of the arms are legally produced. So at some point they are diverted. But detecting the point of diversion is extremely difficult. It can happen at any time, at any moment. The time of manufacturing, time of transfers, they can be stolen from households. There are many different sources for these firearms. So it is a crime that is complex, that is difficult to detect, and it is very difficult to investigate and prosecute. And this scenario A and B that you can see shows exactly what for us is the main problem from the criminal justice perspective. Many arms are seized in countries. If you look at national statistics, you see that some countries seize a lot of crimes, more than 1,000, or even in the tens of thousands. And if you look at how many cases are actually investigated for arms trafficking, very few. So by the simple fact of seizing a firearm and even eventually destroying the firearm, you are not disrupting illicit arms flows. And this is the biggest challenge that we see everywhere, that because most of the illicitly trafficked firearms are detected when they are used in the context of other crimes, even the criminal justice response focuses more on the primary offense. And by not focusing and not investigating the illicit trafficking, we are not only not disclosing possible trafficking flows and networks, we are also not recognizing the dimension and the real importance and impact of this crime. So only by really focusing also on the origin of the illicit arms and on looking at the illicit trafficking flows, we will be able to identify and hopefully disrupt the illicit trafficking. So what is, in our view, a requirement, let's say, to really improve the implementation is to adopt a new paradigm, to move away from this single crime approach and to look at firearms trafficking in the context of the broader criminal context, also in the context of organized crime and terrorism, and to try to establish bridges, not to look at the arms control regime in isolation, but also when it comes to the regulatory regime, bear in mind what exists at the level of preventing terrorism, preventing organized crime, and see how synergies can be established. And similarly, make also full use of the convention and of all its tools in order to push the investigation on illicit trafficking also at the forefront. So this is now very fast. I just wanted to say a few things of what we do to help countries. Un minutino. Va bene. Very quickly, what we do in order to support countries in this regard, we try to have this integrated approach. So we work on legislation, but we also help them in actually implementing the technical aspects. So to actually mark the weapon, to enhance their capacity to secure the stocks, because many arms are getting stolen. The most delicate arms that are the ones that are seized and that are often in the prosecution services or at the police stations because they are not properly secured. And then we work a lot on criminal justice responses. What we try to really promote through our program is to change the investigative approaches. As I said, it is not enough to just detect a firearm eventually at the borders and to seize the firearm. We have to promote also investigations into the trafficking, because if we don't do that, we just make this crime more invisible. And this is what we see one of the major challenges for the firearms protocol. The last activity, our fifth pillar, is also linked to evidence-based information. We have launched last year a global initiative to collect data on seized, found, and surrendered firearms. We do that together with our research branch. And this is a questionnaire that not only looks at how countries are actually monitoring, achieving the Sustainable Development Goal that I just mentioned earlier, but this is also a mandate that we received from the Conference of Parties to actually look better into the context of these arms. What is interesting for us to ask countries is not only how many arms have been seized, and how many and in what type of arms, but also in which context. How many are seized in the context of terrorism? How many are seized in the context of domestic violence or of other crimes? And this will give us a better picture. We hope to publish the first study around October this year. And we also hope to continue this exercise on an annual basis. We believe that by pushing, in a way, countries to reply to this questionnaire, we also contribute to encourage more evidence-based approaches at the national level, so that the fact of sharing the data with the UN becomes a positive collateral effect. But the most important thing is that countries generate the data in the first place and then use them also for operational purpose. So to conclude, I would just like to say that the Firearms Protocol is often called also the Orphan Protocol. We had a former executive director who used to call it like that. It's not really an orphan protocol, but it is more difficult to implement. Today we have 117 parties to it. But in order to fully implement the protocol, it must be adopted, it must be implemented together with the convention, with the parent convention. It cannot be dissociated from it. But similarly, it must also take into account the other instruments, in particular the Arms Control Treaty, the Arms Trade Treaty, which has no enforcement measure, no criminalization provision, but which enriches the control over arms transfers. We also believe that more integrated approaches are needed in order to take into account what the reality tells us, meaning that there are growing links between arms trafficking and terrorism and other forms of organized crime. So we cannot look at this protocol in isolation also from that perspective. And last but not least, criminal justice responses must be more focusing on the trafficking per se and not only on firearms as a tool for the commission of crimes. And more evidence-based data will help shedding better light on this phenomenon. And I conclude with a positive note. As I mentioned before, I am convinced that the review mechanism, as weak as it may appear, at least in this particular field, will be one of the most, of the strongest and most incisive tools that we will have. Because if you compare it with other instruments on arms control, this review mechanism will be the only one that will really help us understanding to which extent countries are really implementing the most relevant provisions, in particular the criminalization ones. So we are really looking forward to start next year. Thank you very much. Thank you.
Thank you very much, Simonetta, for this extremely interesting analysis of, of the content of the protocol, but especially on the work that UNODC is implementing in this field, which for us as researchers is a major source of information. And I really hope that this new exercise, the illicit arms flows questionnaire that you have been promoting, will raise much more participation from the member states, because this is really crucial also to try to launch a campaign in order to sensitize, member states in understanding the importance of participating to this exercise. How many arms, of course, is important, but as you said, in which context, in which kind of crime, terrorism, organized crime, which kind of activity, all these are pieces extremely important of information for us. So thank you very much, Simonetta, for your very important contribution to our conference today. And now I'm very pleased to give the floor to our discussant, Laura Salvadego, who is a researcher in international law at the University of Macerata. And Laura has been doing research related to international human rights law and European migration law and international criminal law. So please, Laura, you have the floor as a discussant.
Thank you very much, Monica, for the floor.
Sorry.
For this invitation today. But my task is just to provide for some further considerations on the smuggling protocol, and as regards the implementation of this protocol, that was the object of a very in-depth analysis by Professor Spena. But the central point of my analysis is linked with the high level of criminalization of humanitarian activities at sea. Both in Europe and Italy, and I think that this aspect is mainly due with the substantial gap, substantial implementation gap between the smuggling protocol and the European Union legal framework, as Professor Spena told, with respect to the facilitators package, that is the existing European Union legislation adopted in 2002. Because this second framework is not fully consistent with the smuggling protocol with respect to a couple of very important issues. First of all, as some inconsistencies and shortcomings are present, and we can find two main aspects on these inconsistencies of the European Union legislation. First of all, as Professor Spena told, a central point is to understand the definition of the economic gain. And with respect to this point, we have to say that Article 3, letter A of the smuggling protocol and Article 6 of the smuggling protocol precisely give a very central importance to this aspect, to the financial or other material benefit, both in the definition of the smuggling of migrants and in the elements of the criminalization of this aspect of this crime. But here we have in Article 1, Paragraph 1, letter A of the Facilitation Directive, a very strong inconsistencies, because here we have that it is said that the financial gain is not to be considered such as strictly necessary for the criminalization of facilitation of irregular entry. And the second central point to my mind is the the inclusion of an exemption for the punishment of individuals providing humanitarian assistance. Because, as Professor Spena told, in the preparatory work of the smuggling protocol, this aspect is central in the definition of the crime, and this both the focus on the criminal intent and the attention to the material benefit that must be present in this specific case were adopted precisely to exclude, to criminalize the activities of rescuers, of individuals engaged in humanitarian assistance. Here, in the Facilitation Directive, in Article 1, Paragraph 2, we can just find a non-binding option for the European Union member states to apply an exception, the so-called humanitarian exception, to this specific issue. In the European Union Action Plan of 2015-2020, this aspect was considered, and the European Commission announced some proposals to modify these shortcomings of the European legislation, precisely with the aim to combat these illegal activities, avoiding the risk of criminalizing the individuals providing humanitarian assistance to migrants in distress. However, to date, as far as I know, no concrete changes have been introduced in the European Union legislation. And this aspect, to my mind, is the central point on which the European, the legislation, the domestic legislation of a number of European Union states show some shortcomings. Because, for example, if we verify the Italian legislation, we can find the definition of facilitating of illegal immigration in Article 12, Paragraph 1 of the Legislative Decree 286 of 1998. And here we have the definition of this crime, such as the conduct of carrying out acts aimed at illegally procuring the entry into the territory of the state. And here the financial gain is just indicated such as an aggravating circumstance and not such as a constitutive element of the crime. Again, here in the Italian legislation, the humanitarian assistance exception is present in Article 12, Paragraph 2, but it is very limited in its scope of application. It just says that it is excluded the possibility to pursue the individuals performing humanitarian activities when the individuals are already in Italy. And so it is clear that in the interpretation of the doctrine, this provision is not applicable to the certain rescue activities performed on the high seas. It is true that this humanitarian exception also recalls Article 54 of the Italian Criminal Code with respect to the exemption of the state of necessity. And the Italian Court of Cassation has, in a number of decisions, based its reasoning on on Article 54, Paragraph 3 of this the Italian Criminal Code, with the specific purpose to avoid the criminalization of the rescuers for the acts committed, partially committed within the Italian jurisdiction, and with the purpose to criminalize the conduct of the smugglers when performed entirely outside the Italian jurisdiction. However, the Italian doctrine had highlighted the fact that the reasoning based on Article 54, Paragraph 3 is not legally well-grounded, because here Article 51 of the Italian Criminal Code should be applicable, because the rescuers are precisely performing a duty to rescue individuals, people in danger of being lost at sea, according to a general rule of international law that is also codified under Article 98 of the UNCLOS, the United Nations Convention on the Law of the Sea. Thus, in my opinion, it is very welcome a judgment adopted by the Tribunal of Ragusa in May 2018 with respect to the case of the vessel Open Arms, in which the Tribunal provided for an interpretation of the content of the crime of facilitating illegal immigration under Article 12 of the Legislative Decree 286 of 1998, and explained on which basis it must be excluded the crime, the perpetration of the crime, with respect to the humanitarian activities performed by the non-governmental organizations. And first of all, the tribunal explained that we have to verify the subsistence of the subjective element, that is, the awareness to carry out illegal transportation of migrants, or to carry out acts aimed at illegally procuring the entry into the territory of the state. Again, the tribunal clarified that the crime cannot be considered such as committed when it is not possible to find some evidence with respect to the collaboration with smugglers and some agreements that must be present with the smugglers in Libya or in other states. And finally, the Tribunal of Ragusa told that it is not possible to criminalize this non-governmental organization when the action is completely performed according to the indication given by the Italian Rescue Coordination Center, for example, and the place of disembarkation of migrants is given by the Italian authority, because in this case, this action must be considered such as a fragment of the obligation to rescue migrants in danger at sea, and so they cannot be considered such as illegal actions, such as crime according to Article 12 of the legislative decree. And so, just to conclude, I think that the interpretation given by the Tribunal of Ragusa in this judgment should be considered such as the sole compatible with the existent international obligation binding for Italy. And so, with respect to both the smuggling protocol and the UNCLOS, because in this case, there is a specific duty to rescue individuals at sea. And so I think that this interpretation should be considered such as the relevant to this specific issue. However, it is clear that legal certainty requirements make legislative reform necessary, not only in Italy, but also in other European states and maybe at the European Union level too. It is clear with the scope, with the purpose to avoid the criminalization of humanitarian activities at sea, that in this moment is a central point of this, of the public debate, we can say. Thank you.
Thank you. Oops. Thank you very much, Laura, for your discussion of part of our, presentations. I'm now very pleased to open the floor for questions or remarks that you might have on the topics addressed in this last panel session. Please.
One thing that has been on my mind for a long time, and on which we heard a couple of things today as well. That is this distinction between smuggling of migrants and human trafficking that is constantly and so neatly defined by the two protocols, but is in fact very much blurred in practice. And what Ruth said earlier on about the difficulty of a trafficked person to find protection as being linked to the undocumented status in many occasions is, I think, exemplary of this difficulty. Do you see any way out of this conundrum, any possibility? I don't think there's any possibility of reforming the two protocols in this respect, but anything that may come up in the future to try and ease this lack of coordination, really, which makes it really a matter of chance whether one is picked in the trafficking box and therefore finds some form of protection, or whether a migrant is simply classified as undocumented, smuggled migrant, and therefore gets no protection at all, even though possibly the two situations are in fact not so much different.
I may try to answer from a criminal law perspective, not from an international law perspective. So I do not know what to say as regards the protocols and the way in which they can interact with each other or can be merged in a way. But from an internal point of view, I can say that the distinction is not so much relevant. In fact, prosecutors find much easier to resort to the crime of smuggling than to the crime of trafficking, which is easier to prove, to have evidence of. So what usually happens, at least in Palermo, is that prosecutors use the crime of smuggling because you just have to give evidence of the fact that an irregular transportation has been done, and you don't have to give evidence of the fact that victims were already coerced from the beginning, that there were some kind of aim of exploitation since the beginning. So smuggling is much easier to use from a judicial point of view, and this is the way in which it is used in practice in Italy. So from an Italian perspective, the problem is not so much problematic, so troublesome, so to say, but on an international level, I don't know what to add.
Yeah, if I can add very quickly, that if we look at the populations, always talking about the phenomena, we look at the population, most of the traffic victims are not migrants. Most of the victims around the world are actually victims of domestic trafficking. And also in Europe, where we have a large part of the victims are actually foreigners, but they are not smuggled because they are coming from certain part of Europe. They are part of the European Union. But it's true, if we look at from the smuggling of migrants point of view, that many of those that are smuggled, then they are vulnerable to trafficking. So it's probably the point is, so we should isolate sort of the population segment that is in this blurred area. And yeah, I think that at the moment the jurisprudence around the world is really to move trafficking persons more to have a major focus on the exploitation. So I see more the confusions in the area of forced labor and trafficking. More and more the jurisprudence is moving to that, to not consider the movement element anymore in the trafficking victims, as the trafficking protocol definition is really difficult, as a difficult definition from that point of view. And while from the overlap of the blurred area with smuggling of migrants is probably more in the concept of vulnerability of smuggled migrants to exploitation.
Just one word. I mean, it's very sad to notice that However, I mean, the human cost, actually, of those phenomena, I mean, arms trafficking, smuggling of migrants, trafficking human beings, still remain very high, actually, nowadays. I mean, of course, beside the difference existing between smuggling and trafficking, which sometimes, as you said, are very blurred, I mean, unfortunately, also the counter effects of certain policies implemented both at international, regional, and national level actually provoke some side effects which actually have a strong impact on the life of people in everyday life. So this is something that, as a sociologist, mostly involved in qualitative research in the field with migrants and refugees, actually we are experiencing and testifying more and more, especially during the past few years, since, let's say, 2015, the so-called refugee crisis in Europe. I mean, the problem is that, I mean, the human cost of this phenomenon are still very, very high, and in some cases are even increasing. Also, as far as arms trafficking is concerned, I mean, having done some research in this field at more international level, but also in the Italian case, it's very interesting to notice, as, I mean, in Italy, where we have one of the most, unfortunately, famous mafia at international level, the number of investigations expressly addressing trafficking in arms trafficking, are very few, if not non-existent at all. I mean, those few investigations actually I mean, didn't actually achieve so very, you know, great results. But unfortunately, I mean, arms allow organized crime groups to play a crucial role within both the legal and illegal economy. I mean, since violence is a crucial resource on which organized crime groups can, of course, count. So, I mean, I really hope that there can be, I mean, a higher level of sensitization at, you know, at international level among countries on the crucial role played by these activity in the context of transnational organized crime operations, which can lead to adopting, you know, I mean, homogeneous instruments also in order to monitor the flows and the various cases. So, any other question or remarks from the floor? So maybe I give the floor to our convener, Serena, for the last maybe words on this great day.
The last words are just to express gratitude to all of you for resisting up to this point, first of all, but also gratitude to those members of the scientific committee who could not be here, but nonetheless contributed significantly to the organization of this event. I would like to particularly thank Gioacchino Polimeni. I had thought of asking him to draw the general conclusions today. He can't be here, but he has been with us nonetheless. And yeah, I hope that we can go on with our dialogue also in the future. Maybe we shall share the PowerPoints that were used today if you all agree, because they have been asked. And we shall think about the idea of publishing some sort of proceedings, which could also be interesting. But I will come back to you on this point via email in the next few days. For the time being, thank you all, and I wish you all a safe trip back home and come back to Ferrara.